Very well, Your Honour. I'll attend to that at the first break.
Defence.
Your Honour, we oppose the application. It's of course for the VW to allay any concerns a witness may have. But Your Honour, there's no risk to this witness in our respectful submission. She is in VW care and she's been relocated. I don't see how, given what the prosecution said yesterday had entered the public domain, why now the hearing should suddenly, the shutters should come down and the hearing be put in closed session. In fact, the reality would militate in favour of the opposite result, that all the testimony should be public. But, Your Honour, the approach that I am submitting to the court is the evidence should be...
1 second. Why is that? You say the reality is that all testimony should be in public.
Well, Your Honour, the prosecution said yesterday that the witness's name had entered the public domain, but the approach that I am commending to the court is that we continue as we did yesterday, seems a long time ago, yesterday, with the protective measures in place, but the testimony should be public, except to the extent when the bench considers private session is called for. In other words, periods where the witness's identity may become public, because if one is looking at defamation or other, one shouldn't republish defamatory comments in the same way that one shouldn't further disseminate something that should not have become public in the first instance. I do, as an aside, say that we alerted just before, in fairness, just before the bench came in, the prosecutor to the fact that we have just received, or it's come to my attention, that from the Kenyan press, a lady has given a statement, and her video is there. I think it's been sent, or it's in the process of being sent to the prosecution, that the photograph that was displayed and talked about the cook's outfit, that is clearly not the witness. I just raised that as an aside. But, Your Honour, we have information, and it will come apparent in the defence case, that there are, unfortunately, a group of witnesses that are lying in the essentials when it comes to Mr. Ruto's alleged involvement in this criminal conduct. And the information we received many months ago, and it will come in our own defence case, and we can reveal it ex parte if the court wished to hear it.
Mr.
Your Honour, just 1 point of respect.
1 second. What I want to know now, I asked you the question as to why you said that the reality now is that the rest of this witness's testimony needs to be done in open session as opposed to private. That is the limited question, and then you can continue from there.
Your Honour, I clarified that. We should continue as we did yesterday with the same protective measures that were yesterday. That's the worst case scenario. That's the maximum limits of the protection that the court determined were appropriate.
But your submission, of course, is not that if attempts are made to reveal the identity of a protected witness, or if indeed the identity of a protected witness is revealed, therefore, from then on, it means the witness has been outed and will have to be heard in open session. You're not making that
No, Your Honour,
suggestion.
that's why I allude to defamation, that if one publishes a defamatory remark, it's an offence to republish, and one should not be rewarded by, an offence should not be continued simply because somebody has done something which ought not to have been done. So I hope I've been clear on that. But, Your Honour, in an ex parte session, if necessary, but you can take it from me, we have evidence that we received months ago that there's a group of witnesses that have been got at by various groupings, intermediaries, and they've been promised closed session hearings. They've been promised by the prosecution and by other intermediaries that their evidence would be behind closed doors. Your Honour, I have disclosure many months ago to that effect. Your Honour,
Mr. Ken, 1 second. We're not there yet about other witnesses. We're talking
overlapping speakers.
in light of what has occurred so far. as regards this witness,
Yes.
not any other witness.
Indeed, but Your Honour, this witness has been handled by a prosecution intermediary, and that's why I say that there should not be a blanket closed session. There are the safeguards, very significant restrictions of her identity cannot become public, her name will not be broadcast. There is, I think, facial distortion, there's voice distortion, but the public have a right also to hear. I don't see how that would cause any prejudice to the witness.
I'm sure the public will understand if effort made by some people, right now we don't know who they are, the public will understand if it is the case that efforts are being made by some people to reveal the identity of witnesses with the obvious intent of discouraging the witness or such witnesses to testify. The public will surely understand that measures need to be taken in the circumstances.
Well, Your Honour, without
overlapping speakers,
difficult to know what the public would think, but I would respectfully submit that the public, or at least myself, I can speak for my own views, when there is facial distortion, voice distortion and no name being broadcast, why shouldn't the subject, why should the thrust of a witness's testimony not go into the public domain except for those aspects of the testimony that may reveal the witness's identity? Your Honour, that's the aspect where there is a well-founded reason to go into private session, where anything may be said that would reveal the identity of the witness. But in circumstances where already the very significant measures of facial distortion, voice distortion, and a pseudonym are in place, the thrust of the allegations against my client should be publicly heard, because we are intending, it's very important to us, that we want to publicly expose the lies in this case. And that should not be hidden between these four walls of this courtroom. That is something that the people of Kenya and the international community and those that have come thousands of miles, including the family of William Ruto, have a right to hear. And that's why, Your Honours, I do submit that the proportionate restrictions are already in place, namely the video, facial distortion, voice distortion, and pseudonym. But we have no intention, with the greatest of respect, of confronting and exposing this witness behind closed doors. I think the world and the public, as well as Your Honours, have a right to hear some of the lies in this case against William Ruto.
Thank you very much. Mr. Caldwell Keegan.
Your Honour, can I just raise one additional matter with your leave?
the interpreters request that the 5-second rule be respected. Thank you very much.
Your Honour, I'm most grateful. The additional point I would ask the bench to consider is we don't want to give witnesses the idea that they themselves, I'm not saying it happened in this case at all, but they themselves or family members that have sat in interviews or third parties can also reveal information, and it would allow what we say are lies to be hidden from the public. So, Your Honour, there is a floodgates argument that should also be considered. But, Your Honour, apart from that, I rest on my earlier submissions.
Mr. President and Your Honours, I have 3 issues to raise on my part, and in principle I oppose the application to put a blanket coverage to the testimony of the witness. The first position is that the protective measures that are already in place, I submit, are adequate. And those measures were targeted at protecting the identity of the witness and her family members. And we submit that the measures that were already put in place were adequate. Mr. President and Your Honours, Mr. Sang came to this court and has the legitimate expectation that the measures that were already in place were adequate. Any changes made in the course of the trial would be unfair to him, and it is unfair considering that in principle the whole trial should be conducted in the open. And we submit that really there is no occasion and there is no reason that has arisen to legitimize the need to make any additional measures in regard to the testimony of this witness. We submit that if the chamber must put any additional protective measures, the prosecution should make a formal application. We should be afforded adequate opportunity to respond to them, and they should be specific. They should not be in the general manner that the prosecution has asked for, that the rest of the testimony be done in a closed session. Thank you, Your Honor, and Mr. President.
Mr. Chatwa Kagan, that specific application has been made, and the chamber is taking oral submissions on the matter. The way we intend to proceed in this case is that there may be instances where certain matters will be appropriate to make submissions upon and oral rulings upon in writing. And there may be instances where applications must be made by counsel standing up, and chamber will then also consider whether to make rulings, oral rulings on the matter, or to render decisions in writing. This is one of those instances where, in light of the flow of events that have occurred, which you've been party to up until now, an application is made as part of that flow, which is easy to understand and respond to and argue. So that application has been made orally, and we are dealing with it in that mode.
In that case, Mr. President and Your Honors, I raise my submissions as already highlighted and insist that it is our submission that the protective measures that are already in place are adequate, and the request by the prosecution should be rejected.
Thank you very much. Mr. Nderitu.
Thank you, Mr. President, Your Honors. I think the circumstances that we are discussing are circumstances that I would call special circumstances. And they are special in view of the already very wide media coverage that there has been with regard to this witness. I am, of course, mindful of Articles 66 and 68, and in particular, Article 68, 1 and 2, with regard to the instances where the chamber may grant exceptional measures in order to ensure the well-being of the witness. In this particular case, the witness is also a victim. And it does appear to me, and it did appear to me yesterday when I visited her after the afternoon session, that indeed her psychological well-being, and that definitely has an impact on the manner in which she would testify, will be very seriously impacted by the kind of measures that she gets. So for those reasons, I would want to associate myself with my learned colleague, Mr. Steinberg, and ask for appropriate measures. I thank you.